Hello and welcome to everybody with this webinar with Justin Bates of Landmark Chambers, where we are going to be discussing the Trecarrel House and Ransfield case, which is about gas safety and Section 21. Justin, tell us a bit about the background to this case.
Yeah, there's quite a lot of background. You have to plough your way through to get to this. You've got to start in a bit of legislation that, although it's very important for the private rented sector, you actually don't see coming across people's desks that often, or at least not my desk that often. You've got to go back to the gas safety regulations. The gas safety regulations are a voluminous code all about gas safety in, for our purposes, we're concerned with residential property. And there are a huge number of regulations you have to worry about, but there are three that are of particular relevance to this case and to the PRS. The first is the requirement to do an annual gas safety inspection, Regulation 36.3. So as everyone listening to this will no doubt know, you've got to get all your gas appliances checked at least once a year. It is theoretically possible to do it on a 13-month time scale once, but for the sake of simplicity, every year do a gas safety check. You've also got an obligation to give the tenant a copy of the gas safety certificate within 28 days of you doing that inspection. And when you take those two duties together, you can understand what they're trying to get at. They're trying to make sure that residential property is safe in a gas sense and that the tenant knows it's safe during the course of his tenancy. But then there's another obligation, and this is one where people struggle in my experience. You've got to give the certificate to the tenant before they enter into occupation. Now, this is a really weird duty because there isn't really any point to it. They've already become the tenant by this stage, so they can't back out of the tenancy. So what's the point of giving it to them prior to occupation? The more sensible thing to do, and incidentally this is what they have done with the electrical safety regulations, would be to say that you've got to give the certificate to any prospective tenant before they become tenant. Because you can well imagine, I'm sure, why someone thinking about renting a property should be entitled to know before they put down any money that it's safe. But that's not what these regulations do. You could have signed up for the tenancy, and only after you've put your money down do you find out whether it's safe or not. So those are the three duties in the gas safety regulations. Now, one of the reasons I think they don't really come across landlord and tenant lawyers' desks that often is because of how enforcement takes place. It's a criminal offence to fail to comply with these, and enforcement is by the Health and Safety Executive. And being frank, enforcement is limited. I've seen some stats from government departments suggesting there are fewer than 10 prosecutions a year. I find it very unlikely that there are only 10 landlords in the country who get this wrong every single year. So frankly, it's another one of those things where criminal punishments are used, and because criminal punishment isn't really the most sensible way of doing it, you don't get a lot of criminal prosecutions as a result. So that's what you need to know for the background about how gas safety regulations work. And then you need to know about things a bit closer to home. And again, everyone in this webinar will know about this. The trend that the governments of all flavours have had since 2004 to use Section 21 of the Housing Act 88 as a soft method of raising standards in the private rented sector. So, I mean, you'll know this, and I'm sure everyone else listening to this will, but the point of Section 21 of the 88 Act is that so long as you've given the tenant the prescribed period of notice, generally 2 months, it can be longer, and presently because of the Coronavirus Act it's 3 months, but generally 2 months notice, then as long as you've got your dates right and got your form right, you've got a right to possession. But since 2004, there's been gradually increasing restrictions on Section 21, which have been used as a way of driving up standards. So tenancy deposits are the first ones. and you and I were chatting just before we came on, the various mess that has been made of the tenancy deposit laws over time. But in simple terms, if you haven't complied with your tenancy deposit obligations, you can't serve a Section 21 notice. Same in the Housing Act 2004 about landlord licensing. Part 2 for HMOs, Part 3 for other properties. If you're not licensed when you should be, you can't use Section 21. And you've seen this trend carry on through a number of statutes, most recently the Tenant Fees Act. If you've taken an unauthorised fee, so one that isn't permitted by the Fees Act, then you can't serve a Section 21 notice until you give that fee back. And this isn't only an England thing. Wales has taken a very similar approach. Part 1 of the Housing Wales Act 2014, which creates a national licensing scheme for Wales. You can't give a Section 21 notice at a time when you're an unlicensed landlord. So the right to use Section 21 has been tied to means of raising standards in the private rented sector. So then you need to look at, we're almost there, I promise you, for background, then you need to look at Section 21 Big A of the Housing Act 88, and this is inserted by the Deregulation Act in 2015. What Section 21 Big A says is that you can't give a Section 21 notice at, quote, a time when, end quote, the landlord is in breach of any prescribed requirements. And the prescribed requirements are things that the Secretary of State adds to from time to time. For these purposes, you need to know that what he's prescribed is Regulation 36 of the Gas Safety Regulations. So let's go back to Regulation 36. That's the one that says you've got to give the copy of the annual certificate within 28 days of you doing the test, and you've got to give a current certificate to any tenant before they enter into occupation. But, and this is what the case is about, having prescribed those two things, the Secretary of State then disapplies some of it. He disapplies it by saying that the prescribed requirement, quote, is limited to the requirement on a landlord to give a copy of the relevant record to the tenant, and the 28-day period for compliance with that requirement does not apply. And what this case is all about is, what does that terrible bit of drafting mean? What has he disapplied with that sentence there? We'll look at the arguments a bit later on, but there's at least two different things he might have done, depending upon where you put the emphasis in that sentence. So that's the background legally. The factual background is relatively straightforward. There's a gas safety test done in January 2017. The tenant moves in February 2017, but she's not given the January 2017 certificate. The certificate is given to her in November 2017. So she gets it, the building was safe, it passed all the tests, but she didn't get it at the right time. She got it, 9 months or so afterwards. So there's a clear breach of the gas safety regulations. The question is there also a breach of the prescribed requirements? They give the noted Section 21 notice in May 2018, and the tenant defends these proceedings. The tenant says, the gas safety regulations say you've got to give me a copy of the current certificate before I move in. You didn't. You gave it to me in November after I moved in February. If we go back to this bit here, the tenant says what's disapplied, the critical bit of that bit that's underlined, is the words, and the 28-day period for compliance does not apply. Because the tenant says, well, the only obligation that's got a 28-day period is the annual certificate. So you disapply the 28-day period, but that doesn't help you, landlord, because this isn't about your failure to give the annual certificate. It's about your failure to give me the certificate before I went into occupation, and the regulations don't disapply the time period for that. Because the time period for compliance has passed, because the time period for compliance is before you move in, you can never remedy it, and so you can never serve a Section 21 notice. And the circuit judge agrees with that. There was an earlier county court case called Clarendon Properties and Monty Schultz, where His Honour Judge Luber had said, yep, that is the reading. What's disapplied is the time limit for the annual certificates, not for the pre-tenancy certificate. And this circuit judge sitting in the Truro County Court says, I've read Judge Luber's decision. It's not strictly binding upon me, but Judge Luber is one of the most eminent landlord and tenant lawyers of his generation, and therefore I agree with him. So the landlord couldn't get possession back under Section 21 ever on this analysis. And you can see why this is a big deal for a couple of reasons. One, the fact you can never fix it means that the landlord who thought he'd granted an assured short-hold tenancy has actually granted an assured tenancy, because the primary difference between the two, as you know, as everyone listening to this knows, is the route for eviction. He's only got the fault-based grounds now as if it was an assured tenancy. The reason why you might think this seems a little bit unfair is the landlord's property was always safe. It had passed the test in January 2017. They'd just forgotten to give it to the tenant. And you might think, therefore, that if the property was actually safe, meaning that you could never get possession back because of an oversight in a form, might not seem the most proportionate response. So those are the facts of the case, and frankly, they're pretty common. There have been various cases where, with some small variant of these facts, where basically, for whatever reason, good or bad, the certificate is in existence, but it hasn't been given beforehand. So the case goes up to the Court of Appeal, and there's a change of representation between the County Court and the Court of Appeal, so I come in and I'm going to argue this case in the Court of Appeal for the landlords. And I have two limbs to my argument. My first argument is you go back to the wording of the statute itself. So if I jump back a bit, there you are. You can see the statute says you can't give a Section 21 notice, quote, at a time when a landlord is in breach of a prescribed requirement. And I say, well, look, the key words are at a time when, because at a time when means looking at whether or not you are in breach at the moment when it happens. It doesn't say the landlord cannot give a gas safety, it cannot give a Section 21 notice if he has ever breached. It looks at whether or not there's a breach at the moment of service of the Section 21 notice. So that's my first argument. My second argument is that, alternatively, you have to read, like jump back a bit, those bits that are underlined at the bottom. So my second argument, and you come back here to what's disapplied, is I say the requirement is limited to the requirement on the landlord to give a copy of the relevant record to the tenant. And I say that's the critical bit of this sentence. What it's trying to do is trying to say that as long as you've given a copy, the timing doesn't matter. That second half of the sentence and the 28-day period for compliance does not apply. Doesn't add anything, I say. I say that's just the draftsman trying to make clear what he means. It's not limiting it. So the governing part of that sentence is limited to, down to the tenant. You could put brackets around the rest and it wouldn't affect the meaning. So those are the arguments for the landlord. Tenant has three main arguments. Now, obviously, their first argument, which I haven't put on the slide, is the judge below was right, which obviously you normally say when you're appealing. The first is that they say, look, Parliament is really concerned about gas safety, and it's something Parliament should be really concerned about. Because, and this ties into their second point, the Health and Safety Executive just isn't the right body for enforcing gas safety standards. It prosecutes a handful of people. It doesn't really have the resources to deal with the whole of the private rented sector. And yes, it is draconian, but it makes landlords provide safe housing. And that's why it's a draconian sanction. It's not like, they say, tenancy deposits or Tenant Fees Act. It's not something as trivial as money. This is about safety. This is the only one, they say, that goes to the safety of buildings. And that's why Parliament's taken a more draconian line. So those are the arguments on both sides. The Court of Appeal split, and they split 2-1 in favour of the landlord's argument. They They disagree with my argument that you can do this all by the statute, by the at a time when. They say, no, the key to all this is in the regulations. And they have got 2 points that the majority say are important. The first is they agree with our reading that the governing part of this sentence here is the bit is limited to down to the tenant. They say you don't need the and the 28-day period does not apply. And they say that the reason for that is to test what the consequences could be. The certificate that you give to them prior to occupation isn't really that important, says the Court of Appeal, because it might only be relevant for a day or two, depending upon where in the cycle you are. The one that really matters for the tenant is the one they get during the tenancy, because if they're going to stay there for a long period of time, that's how they know their building is actually safe. It would be really odd, say the Court of Appeal, if you could be late giving them the more important certificate, which is the one during the tenancy, and still provide a Section 21 notice. But if you gave them the one that isn't that important, i.e. the one at the beginning of the tenancy, then you could never serve a Section 21 notice. So for that reason, they end up accepting that you don't need the words and the 28-day period down to does not apply. You can just cross them out. Their second argument is the consequences argument. And they say the whole point of an assured short-hold tenancy is the availability of possession under Section 21. And if you lose Section 21 for all purposes and for all times, then what you've actually ended up with is a very, very different bargain. You've ended up with a situation where you've actually been granted an assured tenancy. And that's not something you would have expected Parliament to do by such inelegant and imprecise wording. If Parliament thinks people should have assured tenancies, it should say so. It should not rely upon minor technical errors and mistakes in drafting. Now, if I just jump back to the chronology, the more astute among you who are listening to this will have noticed there's a problem on this chronology. Gas safety test done in January 2017. Tenant moves in February. November 17, she gets the January 17 certificate. By February 18, there should have been another certificate, shouldn't there? Because the annual test should have been done in February 18.
There should.
There should. And you'll notice that no one has talked about what happened in February 18 so far. It just transpired. In the chronology, we just go from November 17 to May 18. So what happened in 2018? Well, what happened is this. There is a gas safety check done in February 2018. So it's late. It's outside the 12-month requirement. So there is a breach of the gas safety regulations. There is, however, uncertainty about whether or not that notice from that check was given to the tenant. The landlord says it was, and says it was given in May, just before the Section 21 notice. The tenant says she never got it. So the Court of Appeal have to grapple with two more questions that, until the day of the hearing, none of us really realised were problems. The first is, well, does it matter that if we can ignore the breach in respect of the failure to give the pre-tenancy one, which is what they've said, what about the failure to do the annual check within time? Does that matter? Because the tenant's lawyer argues that no, if you're in breach of the annual check, you shouldn't be able to serve a Section 21 notice either. And the Court of Appeal dismissed that, again by a majority of 2-1. Two of them say it's definitely wrong, and one of them says he isn't sure. They say no, if you don't do it within 12 months, you commit a criminal offence, but it doesn't affect your Section 21 notice, because Parliament hasn't transposed the annual requirement into the prescribed requirements of Section 21. But where you have done the check, and you've got the notice, and you've got the certificate. Although the 28-day period doesn't apply, you do still have to have given it to them before the Section 21 notice was served. And here, we don't know if it was given to the tenant before the Section 21 notice was served, because no one knew until the Court of Appeal hearing that this was important. So what's happened is it's been sent back to the judge in the Trecarrel County Court for a trial about whether or not she was given the notice in May, as the landlord says. The landlord says he went round in the morning and put the certificate under the door, and then in the afternoon to do the Section 21 notice. Or whether she didn't get it at all, which is what the tenant says. If the judge in the Exeter County Court finds that she got it, then he must make a possession order in the usual way. If he finds she did not get it, then he must dismiss the possession claim. And until he makes that finding, the Court of Appeal don't know what the actual answer in this case is. Now, that only really matters for the actual client in this case. It doesn't matter for everyone listening to this webinar. Save that, it does mean that we got another point of law answered through this appeal, which is if you do the annual checks more than a year apart, you commit a crime, but it doesn't affect your Section 21 notice, so long as you've given them the notice before, so long as you've given them the certificate, before you serve the notice.
It also emphasises the critical importance of being able to prove that you've served the wretched thing.
Yeah, absolutely. I mean, what I can see happening is the day before you give your Section 21 notice, I can just see letting agents and landlords adding to the pack of documents that you give to tenants, adding all the gas safety certificates that have ever been relevant to this property. Because presumably, most letting agents and landlords already have a pre-Section 21 pack they serve. The right to rent check, the EPC, the right to rent check, the how to rent guide, the EPC, etc. And to avoid any arguments about service, whether you got them at the right time, I tend to advise people, just give it all again. Give it the day before you want to serve the Section 21 notice. What I would imagine is now going to happen is people are just going to add a pack of gas safety certificates to that and make sure it all goes at the right time. But yeah, it's about record keeping. Proving what you did when is important. And your agents should be able to prove that they did it. If needs be with proof of postage or proof of themselves posting it under the door, whatever it was. Ultimately, being able to prove your steps are important. Sorry, I cut you off.
Yeah, or the tenant signing a receipt. I mean, the one that you give at the start of the tenancy, you can get them to sign a receipt document.
Yes, I mean, you may find they're less willing to sign something if they know that you're going to evict them the next day. But yeah, I mean, if you can do, absolutely. I mean, it's all. This is a bit off topic, but service is all a question of risk management, as you know. I mean, there are some tenants who will deny ever getting anything, in which case the only way to do it is to do a certificate of service saying you hand delivered it and do a photo of yourself posting it through their door whilst holding the newspaper to show you what day it was.
And have an independent witness, I usually...
or video it being done, something like this. But for most people get things that are sent to them in the post. I mean, service isn't, in my view at least, service isn't really a legal question. It's only a legal question if it goes wrong. Service is really a practical question. And the people that are going to deny receiving anything, and you know who they are, you have to take steps to make sure you can prove it. But anyway, that's where we got to at the end of that. So the 2 points of law that are good news for the landlords is late compliance with either of the two certificates is enough. And if you fail to do your renewal within a year, that doesn't affect your Section 21 process. I think there's two big questions left, though. I know you've got questions you want to raise as well, but can I raise these two?
Yeah, sure, do.
Then I'll have a glass of water and hand over to you. The first is, what happens if you didn't do the pre-tenancy check at all, and so you can't give them that certificate? So you've rented your property out. You didn't give them the prior to occupation gas safety certificate. That wasn't because of an oversight, like in Trecarrel. It was because you don't have one. for whatever reason. Maybe you're a bad landlord, maybe your agent let you down, but you just don't have one. What's the answer there? And my provisional view is that would be fatal. Because they say late compliance is adequate. They don't say that no compliance is adequate. And I can see that being a problem that will arise. I mean, logically, it's not a massive jump from late compliance to saying that as long as you gave them one, say, the day afterwards, even if it related to a check done after they become a tenant, what you'll argue is, well, what's the difference? What prejudice have they suffered? But on the way the Court of Appeal approached this judgment, I think that first scenario is a problem. The second scenario that isn't dealt with in the judgment is, what if you are late doing your annual check and you haven't done it by the time of the Section 21 notice, but you should have done? Can that be remedied? So in Trecarrel, they were late doing their check because it should have been in January 18, but they did it in February 18. The question is just, can they prove they gave her the certificate? But suppose they hadn't done it by May 18 when they served the notice. Would that have mattered?
I suppose it depends on the reason why they didn't do it. I mean, a lot of landlords are not able to do their gas safety checks because the tenants won't let them in to do it.
Well, this doesn't turn up in the judgment, but when we were arguing the case, the point that concerned all three of the judges was, what happens if through some totally unexpected reason beyond your control, the check doesn't get done on time? You've got your gas safety engineer turned up, he's ready to go, and then he's knocked over by a bus on the way to do the check. And by the time you find out, more than 12 months have passed. And they were clearly very worried about what happens in the context of good faith mistakes. Now, just in parentheses here, we argued this case in January, and of course by April COVID-19 hit, when you will have lots of landlords who are late complying because they couldn't get in or because they couldn't get people to go out and do the checks. Late compliance isn't a problem. No compliance might be a different question. Now, I agree with you. I can see a distinction between a case where a tenant refuses to give you access, and which is on the face of it a reasonably good reason for not having it, not having a check, and other cases where you just haven't done it because you're a slumlord, let's say. But the answer to that case isn't in this one, because they don't consider those two scenarios.
I mean, so far as the not getting it done when the tenant doesn't let you in, the guidance that's given by the health and safety executive is that you have to have 3 documented attempts to serve it, and if you can prove that you've tried at least 3 times and have got copies of letters that have been sent to them, they're not going to prosecute you.
But that only goes to the prosecution element, doesn't it?
But I mean, that's their guidance that they give. I don't think that's set out in statutory instrument anywhere. But that's just the approach that they take.
I mean, I would have thought if a tenant tried to run that argument, the landlord would meet it by saying, the reason I couldn't do this is because you frustrated me. And you aren't generally, as you know, allowed to rely upon your own wrongs.
Yeah.
To advance a legal argument. It's sometimes called the rule in Mirza and Patel. You're not allowed to say, I broke the law, and as a consequence of which, because I broke it, all these other you have failed in all these regards. So I think the tenant who objectively failed to let you in for some bad reason will struggle. But the problem is you'll have a fight over whether they failed to let you in or not. Because they will say, I was perfectly willing to let you in, just those times were inconvenient.
I suppose it's a question of keeping records again.
Again, it's a record-keeping question. But we don't know the answer to how that will play out in possession terms, because these are the 2 scenarios that are left open without them talking about it. Now, you emailed me before I was prepping for this, and you said you wanted to ask about the Supreme Court. So let me tell you where we are with the Supreme Court. It's a 2-1 decision in the Court of Appeal, and split Court of Appeal decisions are relatively rare. The Court of Appeal doesn't like splitting, because that inevitably means that the argument for the other side must have been a decent argument, because you persuaded at least one Court of Appeal judge. And here, not only did they persuade one, but it's the argument that Judge Luber QC thought was a good argument. And as I said, Jan Luber, when he was a barrister, was one of the absolute leading lights of the residential landlord and tenant bar. So you've got 2 judgments, one in the Court of Appeal and one from a very eminent circuit judge, both of which take a very different view to the majority. I would be absolutely amazed if the tenant didn't try and appeal this to the Supreme Court. If I were the tenant's lawyer, I would try and appeal it, because the argument in favour of the tenant is obviously a decent argument, because it's persuaded 2 very good judges. It is a point of wider importance. It potentially affects millions of tenancies. The difficulty, I suspect, for the Supreme Court, if this doesn't sound too arrogant of me trying to put thoughts into the Supreme Court judges' heads, but the difficulty is, ultimately, Section 21 will be abolished at some stage in the foreseeable future. Both Labour and the Conservatives are committed to abolishing it. The Renters' Reform Bill isn't priority at the moment because of COVID-19, but it's still government policy. It would be surprising if Section 21 is still here 5 years from now. That being so, is this really such an important case that the Supreme Court needs to look at it? On the other hand, they've never looked at Section 21, whether it was the Supreme Court or the old House of Lords. So they might well say, well, we should look at it. And they might say, look, our views on it might be useful for Parliament when Parliament comes to decide what to do. And we'll see what they want to do. They asked the Court of Appeal for permission to appeal to the Supreme Court, and the Court of Appeal refused permission. So they've got, I think, about another month to ask the Supreme Court for permission. I would be absolutely amazed if they don't. As I say, if I were them, I would.
Yeah. Yeah, I was. I mean, we also mentioned this before we started, but I was quite surprised that the human rights argument didn't go anywhere in this case. I don't know whether you just want to mention that to listeners.
So I did have another argument on behalf of the landlords, but it doesn't feature in the judgment, which is why I wasn't going to bore anyone with it. But my argument was this: landlords have an Article 1 First Protocol right in respect of their residential property. And Article 1 First Protocol is the right to peaceful enjoyment of their possessions. There's a long line of cases, including in this country and in the European Court, that say that restrictions on recovering possession can amount to an interference with the Article 1 First Protocol rights. It's all a question of fact and degree, but there are a line of cases from Malta in particular, where Malta has incredibly strong security of tenure, such that if the tenant doesn't want to leave, there isn't very much you can do to evict them. And coupled to that, Malta also has quite strict rent control laws, so people very rarely get into the kind of rent arrears that would mean a possession would have got made. Malta has lost about 15 cases in a row in the European Court, where the European Court keeps saying that giving someone effectively unlimited security of tenure, no matter what they do and no matter how bad they are as a tenant, is a violation of landlords' Article 1 First Protocol rights. So what I was saying was, if you have a reading of the legislation that means that landlords can never recover possession, then that would be a violation of a landlord's right under Article 1 First Protocol, and that would be a reason for not adopting that interpretation of the legislation. Now, they weren't interested in this even remotely in the Court of Appeal. And if this goes to the Supremes, I suspect I'll revive that argument to see if what the Supremes make of it. The weakness, I suspect, and the reason why we're not completely the same as Malta, is that in Malta you can't get them out at all, whereas here you would still have Section 8. So if they were to turn out to be a bad tenant who wasn't paying the rent, you'd have another way of getting possession. So I suspect that's why ultimately the human rights argument won't prove to be the complete answer. But I do think there's something in there. Again, as we were chatting before we started recording this, I haven't got the argument completely down in my head at the moment. But there's something in the point that secondary legislation, what these regulations are, shouldn't really be in the business of taking away rights conferred by primary legislation. And given that the Section 21 right is a primary legislation right, you shouldn't really have secondary legislation undoing that through the back door in circumstances where it's pure happenstance whether or not a landlord loses his Section 21 rights. He's done the check. He's on the way to deliver it to the tenant just before they're going to meet in the park, and he's going to give it to him and then give the tenant the keys. And he's in a car accident, so he can't do it. His agent thinks it's all been done safely, gives the tenant a key, and then the tenant goes into possession. Like, is that really what Parliament had in mind?
I mean, my understanding was that the way it was drafted was that wasn't the intent. I mean, I can understand the reasoning from Jan Luber and the why he reasoned it that way. But my understanding always was that wording wasn't intentional, and it was a drafting error, which the government then declined to go back and correct.
There have been a few sort of off-the-record comments to that effect. Mainly from people at the now NRLA, who say that's what's been told to them by civil servants. And on a more serious note, there are some public statements from ministers that do suggest that this was never intended to be a fatal breach. But the problem is, if I just jump back, I mean, that sentence, the words "and the 28-day period" down to "does not apply," they must mean something. And that was effectively Judge Luber's judgment. He says, look, what was the point of specifying that the 28-day period would not apply if you didn't mean to limit it to the 28-day period? Because on the reading the majority have taken in this case, you can just get your pencil out and cross out everything from "and the 28-day period" down to "does not apply." It's just unnecessary words on their reading. Look, and that's difficult. That's not... One might think that is not the most obvious reading of that sentence. The problem is, that's a terribly written sentence.
Yeah.
And, I mean, as I was tweeting about when this judgment came out, I mean, obviously I'm very pleased to have won it. It's much nicer to go to court and win than it is to go to court and lose. And having received an absolute beating from the Court of Appeal when we did the right to rent case, which I was talking to you about a couple of months back. It's always nicer to be on the winning side than a losing side. But, I mean, the more serious point is, the gas safety in the private rented sector is incredibly important. You know, it's hard to imagine, frankly, a more important thing for landlords to get right. You get deposits wrong. Ultimately, it's only money. But you get your gas safety stuff wrong, someone could die.
People have died.
Exactly. I mean, my dad, before he retired, was a fireman. I can remember him attending numerous house fires where the gas appliances had just gone wrong. Yeah, it's really, really serious. It's the one where you really don't want to mess this up. And to have a situation where the gas safety legislation in this country is so badly written that 3 Court of Appeal judges can't agree what it means, and we have to spend a day arguing about it. I mean, it is not to our credit as a country that we allowed legislation to get into this terrible state, and it's not to the government's credit that, having been told about this problem, and they know all about the Carried House judgment, the Carried Properly judgment, having been told about this, it's not to their credit at all. They don't just amend it. Where you've got badly drafted legislation, particularly when it's only in regulations, you should just fix it, rather than make people spend money to have lawyers go to court and argue about it. I appreciate that means putting me and you out of a job, but
More you than me, I think.
Well, but It's not good. It's not good that people can't understand law.
I think it's horrendous. I mean, there's a movement for plain English for contracts. I think there ought to be a movement for plain English for legislation.
I couldn't agree more. People, I mean, I'm sitting here in my office at home looking at it. I've got the Encyclopedia of Housing Law in front of me. It goes to 6 volumes. It must be now 30,000 pages. It's ridiculous that the law about something as basic as how you occupy your home takes up, what, 2.5 feet on my bookshelf. I mean, that's not good.
And ordinary landlords are supposed to know and understand it.
Yeah, and if they don't, they risk criminal sanction, or they might never get their properties back.
Yeah.
And it doesn't help tenants either, because it means the tenants don't understand what their rights are and they aren't accessible. To have a situation where only lawyers know what law is not a good thing. And this is another example of it.
Yeah.
Whatever Parliament wanted to achieve, it could have expressed itself ever so slightly more clearly.
I remember there was a tweet that you made that the parliamentary drafting had issued a new edition of their guide for drafting legislation, and I remember your tweet said it was.
Yeah, the day this judgment came out, Parliamentary Council, which is the lawyers whose job it is to write legislation for the government, issued their new style guide on advice about how to draft legislation. Yes, one wonders if Parliamentary Council might not want to take this judgment and go away and think about what they've done and have another go at doing it properly.
Yes, and it would be nice if they could be held responsible for the additional costs, but I don't suppose that's ever going to happen.
I don't think that's going to happen. But it's not as if this is an area of law where this hasn't happened before. I mean, I was trying to remember how many amendments there have been to the tenancy deposit legislation.
I think 2 main ones, 2012, 2015. But there's been a lot of problems and a lot of landlords have suffered financially as a result of those issues.
But having to change it twice in 11 years is not good. Acts of Parliament should last forever.
Yeah. I mean, look at the 1925 Lord Property Act. I mean, that's been very solid, hasn't it?
I thought you were going to say that. Well, of course, that's probably one for our area, one of the best known ones. Yep. Passed in 1925, and then frankly, the changes were very rarely to clarify or to fix errors. They were just to update it as new things came along. No, I couldn't agree more. We are not blessed with a healthy statute book at the moment.
Okay, well, I think are there any more points we want to make about this?
I think that's covered all my notes and the things you emailed me about. But I mean,
yes.
you have more of a day-to-day grasp on this. So I suppose, what are you worried about coming out of this judgment?
I think probably what landlords are going to be concerned about is if it goes to the Supreme Court, what sort of judgment they're likely to make. But of course, we don't really know, do we?
Very, very hard to say. I think the bigger problem is it'll be about a year before you get a Supreme Court judgment.
I mean, one of the problems that I can see is that landlords are going to think, right, I have a window of opportunity here to evict my tenants. I'm going to go for it. Of course, they can't go for it at the moment because we've still got the stay on, but they'll go for it after the 23rd of August.
Yeah,
because in a year's time, they might not be able to.
I mean, this is a discussion perhaps for another day, but don't you think landlords, or some landlords, will be looking to do that anyway the moment we start to see what the abolition of Section 21 looks like?
Yeah. Yes, it's likely to happen.
I mean, I would hope that landlords recognise that actually this is a relatively modest decision that protects good landlords against mistakes. Because what matters here is the checks had been done. It was just proving them. And I think that's the takeaway from this. The Court of Appeal did not want to penalise someone who had done the checks, albeit who may be late in providing the proof of them. I think the bigger problem is if you haven't done the checks, I'd be a lot more worried.
Yeah, and I think I'd probably say to landlords that notwithstanding this judgment, it's probably a good idea to serve your gas safety certificate before the tenants move in, just in case the Supreme Court come to a different decision.
Oh, absolutely, yeah. Absolutely.
Okay, well, I think it remains for me to say thank you very much for coming along and explaining this to us, Justin. It's been fascinating, as usual. And I don't doubt that we'll be talking again about some other case at some stage in the future, because litigation continues.
Well, the next one, just to whet everyone's appetite, will probably be Jarvis and Evans whenever we get that from the Court of Appeal.
Is that the Welsh one?
That's the Welsh landlord licensing one. Yeah, very similar to this. If you're an unlicensed landlord, well, you're actually a bit more serious in this one. If you're an unlicensed landlord, you can't serve a notice under Section 21, but are you also banned from serving notice under Section 8? We argued that in the Court of Appeal by video link last week. So we just waiting for a result on that one. That'll probably be the next one we need to talk about.
Okay, well, we'll look forward to it.
All right, take care, Tessa.
Okay, thank you very much.
Bye bye.
Bye-bye.